Rod J. Rosenstein is the 37th Deputy Attorney General of the United States. He advises and assists the Attorney General in formulating and implementing Department of Justice policies and in providing overall supervision to all organizational units of the department. He spent more than 27 years in government service and has previously served as U.S. Attorney for the District of Maryland. Mr. Rosenstein will be joined later for questions by Stephen Cohen, former Associate Director of Enforcement at the SEC, and now a partner at Sidley Austin LLP. It's my honor now to introduce the Deputy Attorney General of the United States, Mr. Rod Rosenstein.
Well, thank you very much. Good morning. Thank you, David, for the gracious introduction. I want to thank Compliance Week for organizing this event and inviting me to speak here today. The Mayflower Hotel, you may know, has a storied history. Many famous public figures have frequented this hotel. J. Edgar Hoover was known for lunching here when he served as the director of the FBI. Sometimes onlookers reportedly would recognize Hoover while he was here, and they would gather to watch him, so the hotel staff would sneak him out through the kitchen and out the back door. And when I got this job, I remember being grateful that I would not have to worry about that sort of thing. Deputy Attorneys General are very low profile, tend not to be recognized. And if they're remembered at all, it's usually for the memos they write about corporate fraud, as many of my predecessors were known for. Now, earlier this month, I attended 2 conferences in New York to speak about white-collar crime and corporate compliance. On Wednesday, I'll return to New York for another speech in the same general area. And I'm here today with you to speak about compliance and talk with risk professionals. These issues are very important to the Department of Justice. They address a high priority of the Trump administration, which is to enhance the environment for business in the United States. And I'm very honored to be here. But I wish there were more Senate-confirmed appointees in the Department of Justice to help with these matters, to give speeches and to carry out our important work. A few months ago, I received invitations to several corporate fraud-related events this month that focused on the department's role, and I had expected to delegate some of these events to those outstanding nominees for Assistant Attorney General who are awaiting confirmation by the United States Senate. Drawing on their highly qualified backgrounds and experiences, they would help implement and spread our message about deterring corporate fraud and promoting the rule of law. Unfortunately, only 2 of the 7 litigating divisions of the Department of Justice have Senate-confirmed leaders. 4 nominees are awaiting Senate confirmation votes, including Brian Benchikowski for the Criminal Division, Eric Dryban for the Civil Rights Division, Jeff Clark for the Environment Division, and Jody Hunt for our Civil Division. Most of them have been waiting an entire year to get a vote for an executive branch job that typically only lasts for a few years. It's an odd way to run a government. Now, fortunately, we assembled a superb team of acting leaders in the Department of Justice, and we are going to keep moving forward. Lawyers, compliance officers, and other risk professionals are at the forefront of advising companies to ensure that their businesses operate legally and honestly. When I look out at this room, at the many successful private sector leaders, I'm reminded of a book by Dr. Seuss. The book is called Oh, the Places You'll Go. How many of you are familiar with that? It includes this advice. You look up and down streets, look them over with care. About some you will say, I don't choose to go there. With your head full of brains and your shoes full of feet, you're too smart to go down any not-so-good street. Now, many of you advise companies and business leaders through challenging corporate decisions. You probably convey to them the same basic advice, perhaps without the rhyming couplets, but the same fundamental advice. And events like this one give you an opportunity to learn not only from the presenters, but also from each other. You can discuss what works and what doesn't. You can identify new compliance risks and best practices. Of course, the fundamental best practice is to simply comply with the law. J. Edgar Hoover is not the only famous Department of Justice official who visited this hotel. Attorney General Robert Jackson spoke here at the Mayflower shortly after he became Attorney General in January of 1940. In that speech, Jackson described Washington as, and I quote, "a weird city where so many are making speeches and so few are listening to them." Now, most importantly for our purposes, in that speech, Jackson spoke about the fiduciary duties of lawyers. He said that most of the mistakes and major faults of our time are to be ascribed to a failure to observe the fiduciary principle, old in equity and recognized by law, the principle of trusteeship, without which our kind of society cannot permanently endure. You, in your function as corporate compliance officers, your executives, you all share a responsibility to promote the best interests of the organization and not your own personal interests. The Department of Justice recognizes that respecting fiduciary duties and upholding the rule of law is a two-way street. We ask companies to act in accordance with laws and regulations, even when doing so may be difficult and burdensome. Strong compliance programs and risk assessments are critical in that effort. We in law enforcement reciprocate by defending the rule of law and protecting the integrity of the marketplaces that your companies depend upon. Thomas Jefferson said that the most sacred of the duties of government is to do equal and impartial justice to all citizens. We must endeavor to enforce the law equally, fairly, and consistently. And when a company creates and fosters a culture of compliance, it creates value. Compliance is an investment in a company's future. Ethical, law-abiding companies can better attract investors and partners. People want to do business with companies that they perceive as honest and reliable. So compliance mitigates risk, making companies more valuable and less likely to incur unanticipated costs that may result from protracted investigations and penalties. Compliance should not be treated as separate and distinct from other business goals. A culture of compliance needs to be fully integrated into corporate culture. Employees should be trained and encouraged from their first day on the job to think about compliance issues when making business decisions. It's an integrated process, not an afterthought. In a company with adequate and effective compliance programs, the legal, compliance, and audit departments are not the only repositories of professionals monitoring and evaluating what the business side does. Everyone is engaged in the effort to ensure compliance. Now, some of you I know deal with managers who are skeptical of the lawyer's role in helping them to succeed. Many of them tend to view lawyers more as transaction costs than as partners in advancing the business's interests. The lawyers sometimes elicit ill will because we tend to nitpick. People generally do not like nitpickers, but the law requires precision and requires close reading. We are the dotters of I's and the crossers of T's. Small details like commas and semicolons matter to us. In discussing the attributes of a good lawyer, the great Supreme Court Justice Antonin Scalia explained that one of the distinctive skills of our profession is to discern ambiguities, inaccuracies, and insufficiencies that would not occur to the ordinary person. To non-lawyers, it sometimes appears as if our job is to find loopholes, argue about technicalities, elevate form over substance. Compliance officers, accountants, auditors, and other important advisors may evoke the same response. But we know that the future of a business may turn on a seemingly minor detail. Obsessing over details, particularly details about compliance, is a central part of our job. In Shakespeare's play about Henry VI, a character named Dick the Butcher proclaims, "The first thing we do, let's kill all the lawyers." Now, that quotation is widely misunderstood. Shakespeare actually was not poking fun at lawyers. Dick the Butcher is not a businessman complaining about excessive regulation. He's a villain scheming to take over the government. And Shakespeare's point is that without lawyers, nobody would need to follow the law. Now, that would be good for criminals, but it would be very bad for business. Capital markets operate best when reasonable rules are promulgated and enforced by lawyers and government officials. The Department of Justice faces some of the same challenges that companies do. We work to instill a culture of compliance From the first day, a new lawyer takes the oath of office in the Department of Justice, an oath to support and defend the Constitution, to bear true faith and allegiance, and to well and faithfully execute the duties of the office. We stress the need to act ethically and to do justice. We expect our prosecutors, our law enforcement agents, and other personnel to be thinking about their ethical obligations with every decision that we make. And we have integrated that into the daily operations of our business. Newly hired attorneys undergo significant training, including training about professionalism and ethics. We impose other mandatory annual professionalism requirements, and we follow up and require our attorneys to complete them. We have a professional responsibility advisory office, which provides guidance to department attorneys about their ethical responsibilities. We also have an Office of Professional Responsibility and an Office of the Inspector General, which serve as internal affairs watchdogs for ethical issues and other violations of department rules and policies. Like the compliance departments in many of your organizations, our internal watchdogs have not always existed. The Office of the Attorney General was created in 1789 with the original Judiciary Act as a one-person part-time job. That was the Attorney General's function at the founding of the Republic. It was almost another century, 1870, before the department created the Department of Justice. Before the government created the Department of Justice. There was, prior to that, no institution in Washington. We had an Attorney General here. We had U.S. attorneys throughout the country, but no bureaucracy here in Washington. The department when the department was created in 1870, the Attorney General was its head. And as the country grew, the department grew along with it, along with our United States attorneys and our law enforcement agencies. Today, we have more than 115,000 employees. But it took more than 100 years after the founding of the department in 1870 for us to create the Office of Professional Responsibility in 1975. That office was created in the wake of the Watergate scandal. It was created for the purpose of investigating alleged violations of ethical rules by our department attorneys. But today, OPR is staffed by a deputy counsel, 3 associate counsels, and more than 20 assistant counsels who work with the Council for Professional Responsibility. In 1989, our compliance function expanded once again with the creation of the Inspector General. The Inspector General's mission is to detect and deter waste, fraud, abuse, and misconduct involving department programs and personnel, and to promote efficiency throughout the department. Our Inspector General has both criminal and administrative authority. It investigates violations by department employees and crimes perpetrated against the department. It also conducts audits and inspects department programs. The department created the Professional Responsibility Officer Program in 1994, putting an ethical expert, a legal expert in ethics in each one of our components. And we formally created the Professional Responsibility Advisory Office in 1999 to provide a centralized hub for advice on ethics throughout the department. The role of the Deputy Attorney General involves providing management for all components of the department. Our overall budget is now in the neighborhood of $30 billion a year. The job of deputy is similar to the function in many of your organizations of a chief operating officer. In an organization the size of our department, we rely on professionals to ensure compliance with a myriad ethical rules, court rules, regulations, and statutes that affect our employees. And we recognize that it wouldn't be sufficient just to have enforcers and experts at our headquarters. We have experts and folks who provide advice scattered throughout our components. When any one of our 115,000 employees makes a mistake, it can affect the entire organization. So I can empathize with many of you and the challenges that you face with companies that often span the globe and face many challenges. When companies do come under investigation, we ask 2 principal questions about the company's compliance function. First, what was the state of the compliance program at the time of the improper conduct? What had the company done in advance to guard against this sort of misconduct? And second, what's the current state of the compliance function? What sort of remediation efforts has the company made after it learned about the conduct to ensure that similar conduct will not happen again? The first question focuses on whether there was an adequate compliance function. The 2008 revisions to our department's Principles of Federal Prosecution for Business Organizations are known as the Philip factors, after one of those former deputy attorneys general. The department in those guidelines directed our prosecutors to determine whether a corporation's compliance program is merely a paper program or whether it is designed, implemented, reviewed, and revised as appropriate in an effective manner. It's not enough just to write down that you're going to have a compliance program. Our prosecutors want to know how it was actually implemented. In that same year, 2008, the department resolved a Foreign Corrupt Practices Act investigation of a German conglomerate with combined civil and criminal penalties of $800 million. The department pointed to the inadequacies of what it described as a paper program that was in place at the time of that misconduct. Now, we also recognize that even the best compliance programs will not stop individual bad actors. Any organization is vulnerable to somebody who gets in the organization and has an improper motive. Corporate compliance programs are sometimes compared to preventative medicine. Getting an annual physical does not mean that you won't get sick, but those screenings, just like a robust corporate compliance program, help to ensure that any issues will be detected and addressed at an early stage. Now, we don't only look to a company's past conduct, we are also focused on the business's health going forward. What can we expect of this company in the future? That concept is reflected in our Foreign Corrupt Practices Act corporate enforcement policy, which we announced last fall. The policy provides an incentive for companies to promptly report misconduct and to fully cooperate, as well as to enact effective remedial measures. Companies that lack adequate compliance measures are less likely to uncover a program at an early stage and offset some of the damage. They're less likely to be able to make a voluntary disclosure that qualifies them for the most significant benefits under our corporate enforcement policy, and they're less likely to stop the conduct before it becomes pervasive throughout the organization. Companies without adequate compliance programs will need to undertake even more dramatic remedial actions in order to change their culture after misconduct comes to light. Now, compliance is not a one-size-fits-all proposition. We don't tell each company exactly what they need to do to have an effective program. If a small business consists, for example, of just a founder, a general counsel, and a handful of employees, the risk profile of that company is going to differ dramatically from a large organization. But as companies grow, risk profiles change. For example, a company that elects to raise funds by going public faces an entirely new set of challenges that calls for new compliance measures. It needs to concern itself with all the laws that govern public companies, including making appropriate securities disclosures. On the other hand, companies that venture into foreign markets face risks under the Foreign Corrupt Practices Act and need to adopt compliance measures that will guard against the potential dangers. Even blue-chip multinational firms with strong pre-existing programs need to continuously reevaluate their risk profiles and adapt to new circumstances. If a company does discover misconduct that occurs despite an effective compliance program, the FCPA policy tells our prosecutors to consider whether the company subsequently analyzed the underlying cause of the problem. A company that properly manages its risk through a robust and appropriate compliance function, one that grows along with the company, will stay ahead of the curve. Our department, as I mentioned, does not use a rigid formula to assess the effectiveness of corporate compliance. We recognize that each company's risk profile and solutions warrant consideration. We make an individualized determination in each case. 2 weeks ago, we announced another policy designed to ensure fairness and promote consistency in our resolutions of corporate cases. The new policy addresses the coordination of corporate resolution penalties across multiple enforcement authorities. We recognize one of the challenges that corporations face is they're governed by multiple regulators in the United States and frequently by multiple regulators in foreign countries as well. We seek to avoid what businesses often refer to as piling on. If you're a football fan, you know that piling on refers to players jumping on a pile after the opponent has already been tackled. It's important for law enforcement to be aggressive in pursuing corporate wrongdoers and make sure that we vindicate all the appropriate interests of the government. But we should discourage disproportionate and duplicative penalties imposed by multiple authorities. Our new policy discourages piling on by instructing department components to appropriately coordinate with one another and with enforcement agencies throughout the United States and overseas to attempt to seek an equitable outcome in joint and parallel investigations of the same misconduct. We incorporated that policy, like the FCPA corporate enforcement policy, into our U.S. Attorney's Manual so that all of our federal prosecutors will be governed by it. And we hope that your companies and clients will never have to confront our policies and enforcement actions. I know most business executives, most employees, and most companies try to do the right thing. A company with a robust compliance program can prevent misconduct. That frees our investigators and attorneys to focus on corporate criminals who pose the most dangerous and imminent threats to the American people, and to other types of criminals, terrorists, drug traffickers, and transnational cyber criminals. Those groups do not have compliance programs. They do not make voluntary disclosures. They are not our partners in keeping the American economy healthy and prosperous like all of you are. So we want you to work with us as we face today's challenges. We need you to help us uphold the rule of law. We're eager to hear from you and other stakeholders. If there are ways you think we can improve, let us know. One of my goals for the department is to improve upon the policies we have now and to eliminate policies that are not working. In order to do that effectively, we depend on feedback, and in fact, in developing the policies that we've already announced, we've received feedback from many different stakeholders, including lawyers and compliance officials, who want to work with us to develop policies that will be most efficient for them and most effective for the country. So I hope that you'll use opportunities like this one to interact with department officials and with law-abiding corporate leaders who share our goals. I work for your Department of Justice. I'm honored to serve in it, and the 115,000 employees who work with me are honored to work for the American people as well. Thank you very much. Thank you, Steve.
Thank you, Deputy Attorney General, for those wonderful remarks. It's a real pleasure to be here and share the stage with someone who has such a long career as a federal prosecutor and a fellow Attorney General Honors Program grad.
Thank you.
Starting your career.
Sorry we lost you.
Well, it's good to be here. I'm going to jump right in and ask you a little bit about the department's recent FCPA corporate enforcement policy announcement in November. We get a lot of questions about that, in which the department instituted the new presumption in favor of a declination for eligible companies that satisfy relevant standards. Some have argued that the presumption in favor of a declination is not the same as a declination. Companies that self-disclose still face the risk of an enforcement action, and as someone who spends a fair amount of time with corporations, corporate boards, and their management, why is this sufficient additional comfort to encourage more companies to come forward and voluntarily self-report?
So it's true that a presumption is not a guarantee or a promise. And the reason for that is that we recognize that every case needs to be evaluated based upon its individual merit. And so what we've done in this policy is not to provide a guarantee, but to provide guidelines and to be transparent about it. These guidelines are incorporated in our U.S. Attorney's Manual. It's not just a memo, it's actually department policy. And so it's available to all of our attorneys and agents. It's also available to the public. And so you'll know exactly what the process is going to be for our attorneys in evaluating whether or not to pursue sanctions against a company. And we think it's important for us to have guidelines. One of the things that's a little bit confusing sometimes is that these are not legally enforceable guidelines. The department has discretion in how we go about these things. So as a legal matter, we're free to prosecute, not to prosecute, or to do anything in between. But what we want to do is provide some clear rules that govern our prosecutors and that also provide guidance to the private bar, to the defense attorneys who are interacting with us. And so I find these to be very effective, although not necessarily dispositive in any case. In this particular instance, though, what we did is we said, look, here are the factors that we think are most significant when we sit down at the end of an investigation and evaluate what kind of penalty to exact or what punishment to impose on a corporation. Let's look to, obviously, the nature of the conduct, how egregious was the violation. But let's also look to whether the company voluntarily disclosed it, whether the company took appropriate remedial action, and whether the company cooperated with us in trying to identify the wrongdoers. When companies come in and it's clear that they've been guilty of wrongdoing because corporate employees have violated the law, they always portray themselves as victims. Like, our company tried to do the right thing, we had appropriate compliance measures, we hired a rogue employee who violated the rules. And our position is, if you want to be treated like a victim, we expect you to act like a victim. Somebody who's a victim of a crime is going to be eager to assist the government in catching the perpetrator. And so a company that comes in early and discloses misconduct, that cooperates with us in pursuing individual violators, and that takes remedial action to ensure that it won't happen again, is going to get the most consideration when we determine whether or not to pursue charges and what sort of financial penalty to exact. With corporations, generally it's a matter of financial penalties, obviously. You're not sending the company to jail. And so although there is no guarantee, I do think these guidelines are very helpful because they provide a basic framework for how we go about this analysis. And from my experience in the department, actually is very effective. Our attorneys are very conscientious. They want to do the right thing. They want to be consistent. And this gives them an opportunity to apply standard policies in different cases. We also, in developing this policy, we initially had a pilot program. So we initially rolled it out on a preliminary basis. We saw how it worked. We sat down and talked with our prosecutors and with private stakeholders and made some revisions of the policy and ultimately arrived at the model we rolled out last fall.
Terrific. Maybe it's early days and too soon to tell, but have you found any change yet in how companies are behaving as a result of the policy, or are you still waiting to see how that plays out?
We got very good feedback about the pilot program, and since the formal policy has gone into effect, it's been about 5 or 6 months now, we are getting very good feedback. Obviously, this is the sort of thing that's going to take time in order to measure the long-term impact. But the feedback that we are getting is that it is providing some reassurance to companies. It's giving them more confidence about coming forward early and about fully cooperating. And we intend to announce when there are results where we can demonstrate that a company has done the right thing and taken advantage of the policy, and that the department has shown leniency as a result. We had one that we announced a month or so ago. And you're going to continue to see examples like that, I believe, in the future.
I certainly applaud the department for that. It is true that public announcements like the one you made last month really help those who are trying to work with companies to make those decisions, really demonstrate that there's concrete benefits to coming in and self-reporting.
Right.
I'm sure this audience would be very curious to know, putting aside remediation and cooperation, how does your evaluation of the company's compliance program factor into the decisions around how companies are treated when you're doing that analysis for prosecutions?
That's a very important component of our analysis. As I mentioned in my remarks, we don't have a federal mandate as to exactly what your compliance program needs to look like, because every business is different. But what we do look to is whether or not it's taken seriously by the company. Was thought put into developing a program that addressed the potential vulnerabilities? Did people sit around and think about what the vulnerabilities were, given the risk profile of the company? And did they take appropriate measures, not just to put it in writing, but to actually implement it? If you go around the Department of Justice, for example, if you pick out any attorney in the Department of Justice and you ask him or her about the department's compliance programs, I will wager that you're going to hear that they understand their ethical responsibilities, that they've been trained on them. They're trained on them every year. They're reminded of them quite frequently. You ought to have the same sort of thing in corporate America. People ought to understand that these policies are not just written there in order to satisfy some bureaucratic requirement, but it's actually a reflection of corporate culture. And when you go into companies that operate that way, you see that. You see the messaging from corporate CEOs. People hear about it in their interviews. They learn about it in their orientation programs. They see the company take appropriate action when there are violations. And so that's what the department is looking for, is really whether or not there's a compliance program that was designed with the company's risk profile in mind, that evolves to fit new challenges, and is actually implemented in a way that all employees of the corporation understand it.
Are there any particular aspects of a compliance program that as a prosecutor you've seen over the years that you sort of wish companies really got better? Something they should really focus on, whether it's resources, whether it's structure, whether it's other aspects of the compliance program?
I think one of the most significant issues is the ongoing or continuing reminders. Often companies will put into place a compliance program. Maybe people get trained on their first day on the job. Maybe they sign a piece of paper or go through a training program. But what kind of follow-up is there? Companies have constant turnover. People are coming and going. And I think it requires a regular update. In the Department of Justice, the way we do it is by imposing these annual training requirements and by controlling the content from Washington so that we know what our folks are learning. And we can highlight areas where there have been weaknesses. We actually have in my office an attorney whose primary responsibility is to evaluate ethical lapses throughout the department. And every year he provides an update. Here's what went wrong last year. What can we do to prevent those sort of problems from occurring in the future? So I think that's the most significant thing, the follow-up, making it not just a one-time event, but a continuing responsibility of folks in your organization.
I suspect that's music to the ears of a lot of folks in this audience. One question I get at conferences like this a fair amount is whether the Justice Department intends to hire a new compliance officer and continue to develop corporate compliance expertise within the department.
I don't have an answer for you about a particular employee, but I do know I've spent a fair amount of time talking with the attorneys in our fraud section of Maine Justice, and obviously with U.S. attorneys around the country. And the folks who are doing these corporate prosecutions are very sensitized to this issue of understanding what the compliance programs are all about. So whether we have one person in Washington is relevant, but not dispositive. What's really important is that everybody involved in our corporate investigations is familiar with the issue and understands what they should be looking for. And I think that this new policy really accomplishes that, because we put that right in the U.S. Attorney's manuals. They understand it's their responsibility in corporate cases to evaluate the compliance program, and that's going to lead to their developing even more expertise about what compliance means.
So speaking of your predecessors, one of your predecessors wrote one of those memos you were alluding to, I believe, the Yates memo. Sally Yates authored a memo that requires companies to turn over all information about individuals regarding FCPA liability in order to receive cooperation credit. Is that still department policy?
It is, and in fact, it's reflected in the other policies that we've announced. We're not soft on corporate crime by any measure. Our goal is to make sure that we deter corporate crime and we prevent it from occurring in the future. And the way we do that is by ensuring that we hold individuals accountable. It can be very effective to exact penalties from corporations. Obviously, that's a deterrent, and it's an effective punishment when there have been violations. But the most important thing for us to do is to make sure we hold individuals accountable, because it's the individuals who are making the bad decisions that are causing corporations to violate the rules. And so this provision of the Yates policy and our FCPA corporate enforcement policy and even our piling on policy recognize that one of our goals is to ensure that we focus our agents and prosecutors on identifying the individuals who are responsible. And if you're representing a corporation and that corporation is looking for leniency, they ought to join with us in ensuring that whoever was responsible for bringing dishonor on their company by violating the rules is held personally accountable for it.
Now, I've often worried about, in this context, and I hear this since I've left government, from compliance officers who worry that when compliance failures arise, that they are can be an unfortunately end up in the line of fire. I've never personally been a believer in what I think is a bit of a canard in the press, that sometimes that compliance officers are under siege or under attack by the government, or there's any desire to go after compliance officers. I'm curious about your views on whether you think compliance officers, I'm not talking about those who actively commit fraud, but are sort of in the department's line of sight specifically in the context of individual
I think we ought to take a poll. Does anybody feel like we're targeting compliance officers? I hope not. No, I mean, obviously, most people going into this line of work are particularly concerned about following the rules and abiding by ethical standards. And so we view you as allies. I mean, I wouldn't rule it out. A compliance officer obviously can go rogue too. But generally speaking, the compliance officers we recognize are there to do the right thing.
That's helpful. You mentioned earlier the new piling on policy. And in announcing the new policy that you discussed earlier, you mentioned increased cooperation with your foreign counterparts. With all the compliance officers in the audience, I'm curious if there's any particular areas or regions of the world that the Justice Department is focusing on.
I wouldn't say the particular regions. You know, we follow the evidence, and so certainly there are areas of the world that have less effective enforcement and therefore are more vulnerable to violations. But from our perspective, the department has a limited amount of resources, and so we want to make sure that we screen all potential cases and focus our resources on the cases that are most egregious. And we don't single out any particular region or country in that approach.
And any remarks you could make about the cross-jurisdictional cooperation and data gathering in these investigations that you're seeing?
We have, as you mentioned, the piling on policy, which is formally known as the policy on coordination of enforcement and penalties, is really an effort to coordinate within the department, across the federal government, with agencies like the SEC, where Stephen worked, and also with foreign countries, because that's a particular challenge now for American corporations that operate globally, is that they need to worry if they settle a case in one country, they're going to have to face the same issue again in all the other countries where they operate. And so our goal is to enhance our coordination with foreign regulators. And I think we've been very effective in that. I believe in the last 2 years, we've had about 8 joint resolutions in our FCPA cases where we have been able to work with foreign regulators to arrive at a unified resolution, which is really ideal, obviously, for companies that want to do the right thing. They want to resolve their liability, put it behind them, and move forward. And it's much more efficient. And from an enforcement perspective, in particular, it conserves our resources if we're able to resolve a matter once and for all and then move on and investigate other wrongdoers rather than piling on and having various agencies pursuing the same entity for the same misconduct.
That's incredibly helpful, and I think people are really watching to see how this policy evolves. We're winding down to our last minute, so maybe I can offer you a closing question. You mentioned in your remarks your empathy for compliance officers from your role, your oversight role, given the compliance functions that the department itself has. And I'm wondering if you can offer any advice for compliance officers who themselves often face unwarranted criticism and pressure as compliance officers. So, and maybe you might be able to offer them some thoughts about that.
I actually have a countdown clock. I have 42 seconds.
Yeah.
Yes. I mean, I've been in management positions for probably about 17 years now. And I think the best advice I can give you is to stay vigilant, to make sure that everybody in your organization is properly trained, and take that on as a proactive responsibility. As I said, if you look around your organization, you probably can figure out where your vulnerabilities are. And that's the most significant thing I found, not just as a manager, but as a prosecutor, prosecuting all sorts of different cases. You can see vulnerabilities, and it always strikes me when we prosecute a particular case, for example, people think, oh, well, we solved the problem, we've eliminated the bad guy, we've held him accountable. But often the cases reflect some systemic failure, and often it's a failure of oversight. And so auditing efforts, for example, are really critical, a central part of compliance. I remember a case we had in Washington, D.C., where a woman who ran the tax assessment office in D.C. was able to defraud the government of about $50 million. And she started small with minor fraud, but she realized that nobody was paying attention, and so she got more and more greedy over time. And that's an illustration. We prosecuted that individual, but I believe that the authorities also instituted an oversight and compliance auditing mechanism to prevent that kind of violation from happening in the future. And I'm afraid I'm over time.
I suspect the audience enjoyed your remarks as much as I did. Thank you very much,
Steve.
Deputy Attorney General.
Appreciate it. Thank you very much.